Start with an easy one. Being an estate planning attorney, what is estate planning?
Yeah, it's a good question. Very common one too. So in its simplest form.
Hey, welcome. Thanks for joining us today for Tidecrest Expert Series. Today we're joined by Dan Finn, estate planning attorney. So Dan is a lifelong California native, such as myself. Went to USC, for undergrad. Went on to found Finn Legal Group, where he's offering flat fees, transparency, and client-focused service. And he helps families and business owners plan through education and other needs that they have and legacy planning. He's a husband, father, active outdoorsman, enjoys the beach, volleyball, golf, and travel. So Dan, again, thanks for joining us today. So really what we wanted to talk about today, as I mentioned in the intro, is the basics of really what is estate planning. We'll go through a couple of bullet points. We'll let you kind of share your expertise. We're looking forward to that. But trying to figure out, well, how has estate planning evolved for me as my estate changes, right? Or as I'm young and earning and accumulating versus maybe when I've accumulated quite a bit and trying to figure out what the next step is. Okay, to kick things off, we'll start with an easy one. What is estate planning?
Yeah, it's a good question. Very common one too. So in its simplest form, I would say estate planning is a set of legal decisions that a client makes to administer their assets if they become incapacitated or pass away, to also make guardianship nominations for minor children, and then put people in charge of their healthcare decisions should something happen to them.
Yeah, that's much better than I would have done. So I'm glad you answered that question. So what are the key documents everyone should have in their estate plan? I think to me, this is probably the question we get most often is, okay, what is estate planning? Maybe you can read that on the internet, but what does it really entail, right? Mm-hmm. There's a lot of things that could be part of your estate plan. I've told people like kind of estate planning 101 requires a few documents. So love to get your more polished version of that. So talk about some of the key documents you should have in place when you're putting together an estate plan.
Yeah, it's a good question. So there's really 4 sets of documents that I would say are the foundation of any estate plan. So the first one is your will. And typically in a will, you're going to name who your guardians are of your minor children. You're also going to discuss where your assets are going to go. And then you move on to the next document, which is a trust. Trust is a private, structured way to organize your assets and then distribute them in a way that you want to if you're incapacitated or pass away.
Okay.
Next, I would say is what's called a durable financial power of attorney. That's just a fancy way of saying that you're going to leave somebody responsible for your financial assets to pay things like medical bills, groceries, anything that you would need to pay from like a normal checking account if you are incapable of paying for those items yourself.
Okay.
And the last set of documents would be a advanced healthcare directive. Advanced healthcare directive is kind of like a power of attorney where it includes you picking someone that would make healthcare decisions on your behalf, again, if you can't make them for you. And that is more about the relief that you provide for loved ones by making the decision ahead of time.
Okay, great. So the one document that we are most involved with here on the wealth management side is the revocable living trust. We talked about that. I think it was number 2 on your list. So can you talk a little bit about 2 things? One is, how does it benefit families, right, specifically? And then one of the questions we get a lot is, does it provide asset protection, right? And I think it's important to understand that too.
Sure, yeah. So trusts greatly benefit families. So the first way I would say, and probably the most obvious way, is that it's probate avoidance. And a typical follow-up question I get is, well, what is probate? So if you don't have an estate plan, the state of California has made one for you. And the way that they administer that estate plan is by taking you through a court administration process of your assets called probate, okay? So a probate judge will appoint what's called an executor after you've passed away, and that executor it will be in charge of distributing your assets and following all the rules along with probate. Probate, on average in California, is a little over 16 months long. It costs about 5% of your gross worth, depending on the asset, and it's public information. So you can go online and go look up the assets that Prince had, who they went to, and how much they were worth.
Because he had no trust.
He had no trust.
Wow, okay.
Okay. And when you think about families that have minor children, the last thing you would want to consider is having all of your hard-earned assets on a public website and going to your minor children.
Right.
You would, it's an item that you would want some discretion.
Yes, absolutely. That's great. No, really insightful way to explain it. Talk a little bit about asset protection, because I think people ask us and they think, well, does this protect me from creditors and other things like that? And it really doesn't, right? So, I mean, maybe that's my understanding. So help us understand what kind of asset protection is associated with a revocable living trust.
Sure. So let me go back one step. I'll just define what a revocable living trust is. So it's basically a contract between three parties, okay? Your first party is called the grantor, and that's the individual that creates the trust. They write all the rules, they put all the people in charge that are going to administer the trust on your behalf, and they also name the beneficiaries, okay? The second person is the trustee. That's the individual that is the fiduciary that has a responsibility to administer the assets in accordance with how the trust says they should be administered. And then the third party is the beneficiary, the person that benefits from the existence of the trust. While individuals are alive, they are all three parties. So if you have a husband and wife that create a revocable living trust, they are both the grantor, the trustee, and their own beneficiaries as they're living. There's also no asset protection while they're living. There can be asset protection after one or both spouses pass away, but then we get into the realm of irrevocable trusts.
Right. Okay, good. And we'll leave that off for today. It'll come up, I think, in some of the examples we talk about later, maybe from a high level.
Yeah.
We wanted to ask also, so why is estate planning important for everyone, not just the wealthy? You talked a little bit about probate, and that's going to apply to everyone, regardless of net worth. But talk a little bit about why it's important for everyone, not just the wealthy.
Yeah. So if you have minor children, you should definitely have a will that names the guardians of those minor children should something happen to you. That applies to everyone, regardless of your net worth. Right? You don't want in family fighting over who's going to raise the child, and if you do, then you're going to have to go through guardianship proceedings in that same probate court that I was discussing, and that can get ugly. Okay. Yeah. Then additionally, just from a healthcare standpoint, if you have an advanced healthcare directive, you want to make decisions now while you're healthy, so that your loved ones aren't forced to make tough decisions for you when you're not able to as well. And then finally, I would just add that it's important to ensure that the assets are passed down to your beneficiaries in a way that you want to protect them. So, for example, let's say you're, if you're living in Southern California, there's a good chance like you own a home and you have, let's just say, $1 million in net worth, and you want to pass that down to your children. You have two kids, and they're under the age of 18. But if something happens to you and you pass away, and then those kids turn 18 and you don't have an estate plan, it'll go outright to both of those kids. Now, I don't know about you, but I don't think I would be the same person I am today if I was given $500,000 when I turned 18, because I wouldn't know what to do with it, and I'd probably get in trouble. So I think ensuring a positive future for the next generation is just as important and applies to estate planning.
Yeah, good. Okay, great. Thanks for clarifying that. Okay, well, let's talk a little bit about some of the common mistakes people make when they're setting up their estate plan.
Yeah, there's a lot. We could have a very lengthy discussion over the common mistakes, but I'll mention two that I think are widely prevalent. So first one is not updating the trust over a period of time. So you think about maybe where you were specifically when you had young children and how you wanted to make decisions for them and decisions that were the best for them at a young age. Those decisions are going to change as they develop, but then as your assets grow as well. You may become charitably inclined, maybe taxes are an issue, or you may want to ensure that they're financially educated before they get, a lump sum of cash. The second pitfall, I would say, is an unfunded trust.
Right.
So, sometimes you see individuals, or I get clients that come into my office that have already had a trust established, and I look at the schedule that's at the back of the trust. It's supposed to list all the assets, and there may be no assets listed there, or if they are, they haven't retitled the assets to be in the trust's name or changed beneficiary designations.
Right.
And the problem with that is then all of those assets remain titled in the individual's name, and if they're titled in the individual's name at their death, then they go through probate. Right. So there's no real difference. I tell people this all the time. There's no real difference between an unfunded trust and just having a will. So if you're going to go through the time, money, and expense, I would say, for creating a trust, just do it properly and work with somebody to make sure it's funded accordingly and it works the way you want it to.
Yeah, that's a good point. We've actually had a couple situations where we talked to someone who their loved one, usually a parent, was in the hospital kind of on their final days, and then they would have somebody come in and help them with the trust and feel like everything was all good. And we set up the trust and they didn't fund anything, right?
Right.
So that's a really important point. I think that's probably the most common mistake that we see on our side, because we're dealing with account titles and we're dealing with people kind of moving money out of the estate into kind of the beneficiaries and the heirs. And so we see that one quite a bit. More than you think. Like you said, after the time and energy it takes to create the trust, and then how often it's not funded. I don't know what the percentage is, but it's higher than you would think.
Yeah, it definitely is. One thing that I just found that I'm starting to implement in my practice, so there's something called a Hegstad petition. Okay, so this is what happens when somebody doesn't fund the trust but shows some intent to fund the trust. So you basically draft this petition and go to a probate court to ask the court to fund it, to basically act on behalf of the trust or the grantor that passed away. Let me back up really quick. Normally, if I were to file a Hegstad petition in like Orange County or LA County, it's at least 4 months, more like 6 months, to just get in front of the judge for the hearing. There's a county now that is allowing ex parte petitions, which means I can file it and be heard the next day.
Wow.
So it dramatically shortens that time frame. And you think about beneficiaries like wanting to receive assets or not go through a probate process, just from a cost perspective. We're talking about 5% of the gross worth, and then a 16-month period to actually obtain those assets. It's hugely valuable.
And let's talk about some scenarios. I think people gravitate towards scenarios. We have a wide range of clients that we work with. Everybody we work with, I would say, is successful. That's kind of a general term. So you could have a net worth of, 1 to 5 million, or you could have a net worth of over 50. And I think estate plans do evolve over time, and there's probably some component of those 4 key documents that are kind of evolve into those estate plans for those different levels of wealth. But let's talk about it. Let's keep you on your toes here. Talk about a couple scenarios. So, example would be a couple in their 30s, married with children, net worth of $500,000. They're probably in the beginning of what we would call the accumulation phase. They probably both have good jobs. They're saving some money. They're funding their 401ks. They got some, some qualified accounts. Maybe got a few dollars in the bank to save for a house. Maybe they own a townhouse, something like that. Talk about what that estate plan might look like from a high level.
Yeah. So I think the goal for someone in that scenario would really be guardianship nominations, and then a basic distribution of assets. And that would involve a revocable living trust. So with the will, you want to sit down with them, have a conversation, and ask them, hey, let's name some guardians. Who are some people that have similar values to you that, God forbid, should something happen to you, can raise the kids in the way that, you would want to see them raised. And then 2, let's set up the revocable living trust and let's fund it accordingly, kind of in the same way we were talking about. So let's change the title of maybe some brokerage accounts that are under management with like a wealth manager like yourself, and ensure that it's funded. And then from that point, we would want to look at, hey, maybe we should incorporate some life insurance here. Ensure that, hey, if something does happen to you, that maybe the trust is the beneficiary of that life insurance policy. Because if the trust is dictating how the assets are distributed and who's going to be managing those assets, then it's great to kind of provide some liquidity to that trust to be able to take care of the kids or whoever may be the beneficiary at the end.
Yeah, good point. I like that. So let's take it up a notch in terms of age and net worth. So let's think about a couple in their 40s, married, teenage children, net worth of $5 million. And that's going to be a mix of maybe equity in their house, investment accounts, maybe equity in a business that they own, whatever it might be. So let's talk about how it might start to evolve a little bit for those folks.
Yeah. So for those folks, it's probably, it would be tax optimization. It's a goal, maybe some business succession planning, and even some asset protection at those levels. So what do I mean by tax optimization? So if they own a home in Southern California, we want to make sure that the home is titled correctly, or not Southern California, anywhere in California really. So depending on how you hold title to a home or any real property in California will determine whether you're going to get a full step up in capital gains basis after you pass away, or after one spouse passes away, and then a double step up after a second spouse passes away. From a business succession planning, if somebody has a small business, we'd want to look at, hey, what is the business? What kind of business is it? Is the individual the business? And if so, is there key man insurance on that individual, right? So if something happens to them, is there some kind of insurance policy that's going to provide liquidity to a spouse when the business essentially goes away, right?
Yeah.
And then additionally, we would look at, maybe incorporating some asset protection at this point. So we can do that, and I know we alluded to this earlier, by creating irrevocable trusts depending on whether one spouse passes away or both spouses passes away.
Right,
So.
Good. Again, these are high-level concepts, right, that may or may not be used at each of these levels, but I think it is important for people to see and understand like it does evolve over time, and there's a need to do it, obviously, on the high end. I think the assumption is everybody does estate planning, ultra wealthy, ultra high net worth, if you will. But it does make sense to kind of have planning that graduates up as you go. So last scenario we'll talk about, somebody, let's say 60 plus, let's say they're still married, adult children, grandkids probably, substantial net worth of 50 million, right? That's usually in our world, when we see somebody get to that net worth, there's usually business ownership in there at some point to create that, or heavy involvement in real estate. I would argue if you're actively investing in real estate, that is kind of your business, your business equity, if you will, to a certain extent. What are those people thinking about that maybe the $5 million couple's not thinking about?
Yeah, so if we're talking about 50 million net worth, there's definitely some business succession planning, kind of like you said, and it's really two things. It's real estate, or it's some business that the individual has grown over a period of time. And there's a number of follow-up questions we would ask there. So one, what does succession planning mean for that individual? Do they want to pass it down to the next generation? So is there an employee, or is there family that they want to give the business to? Or what happens if there is no family? Then are there things like something called like an ESOP? Do you want to give the business out to employees and receive substantial tax breaks from doing so? And then I would also add upon that, so if you're at that amount of wealth, we're talking about legacy planning, right? We are definitely incorporating irrevocable trust, and there's going to be things like there's all these acronyms for irrevocable trust. There's ILITs, SLATs, GRATs, CRUTs, all of these different ones, and they all have different purposes. But I would want to discuss with the client, hey, what's your goal here? Do you want to set up your subsequent generations, and to do what? And so there's things also we would probably incorporate called dynasty trusts, where you can make a gift to dynasty trusts, and then that gift can grow estate tax free in perpetuity, essentially. So
that's great. I mean, I made that difficult for you because I know that any kind of meeting with somebody with a net worth of 50 million, even 5 million, is going to be a detailed conversation about many, many things. And so, but I appreciate you taking the time and trying to distill it for us and for our viewers and people that are tuning in and our clients and people that are thinking about working with us or thinking about doing some estate planning. So we appreciate you taking the time. So I want to kick it back over to you for California residents that maybe are thinking about their estate plan, thinking about what comes next, either redoing it or starting it. How would you proceed?
Yeah, I would recommend anyone just reach out to a trusted trust and estates attorney. There's plenty of good ones in the area. I can tell you a little bit about my firm's process. So we take intakes, we gather some information, some preliminary information from the client, and then have a sit-down 2-hour meeting with them. And that's at no cost to the client. So I would say just get started. Just take that first step. It's a huge weight off your shoulders when you do, and you'll leave the office feeling a lot better.
Good. In closing, we want to make it clear this is not legal or financial advice. We recommend you reach out to a professional in this particular case for estate planning. Dan or someone like Dan who's a licensed estate planning attorney in California if you're a California resident. We really appreciate you taking the time. Connect with us, follow our videos, find information on our firm in the link below. We'll have Dan's information in there as well, so feel free to use that to reach out to him as well. Until next time, thanks for joining us.